Thank you, Mr Chair.
I call Jacinda Ardern.
I did have a couple of more comments I wanted to make on part one, so I'll make a quick call on those. Mr Chair, before I sat down, I started to talk a little bit about Clause 7 of the bill, and this was the clause which makes very specific reference to repeat offences having the presumption of a term of imprisonment attached to it. The reason I wanted to speak to this is because there was some discussion, obviously at Select Committee, over the increasing use of giving much more prescriptive guidance to the judiciary around expectations of sentencing and whether or not this was considered a good or bad thing. General view seems to be that actually leaving sentencing to the discretion of the judiciary should be our presumption as legislators. However, I do think that there is room for a category of offences where we know there is a particular pattern of behaviour, where there's a bit more understanding of the psychology of this kind of offending, and I think anything related to child sex offences, there is some specific knowledge base behind that type of offending. Certainly that feeds through into at least the treatment plans that seem to sit within our correction system around the idea that there are certain patterns of behaviour that are perhaps more predictable than other forms of offending. I'd be very interested if I'm wrong, happy to be corrected by the Minister on that, but that's generally the sense I've got since holding various portfolios in this area. So there seems to be a comfort, at least, with saying, well, if you see a pattern of behaviour where you have repeat convictions, we do think that therefore it requires an escalation, and that escalation being a presumption that there would be a particular sentence applied to that individual. The way it's set out in the legislation is to state, under Clause 7, it applies only to an offender who has been convicted of and is to be sentenced in respect of a specified publications offence committed after the commencement of new section 132B, and before the conviction for the repeat offence was entered, have been convicted of one or more specified publications offences committed before or after that commencement. The issue that I wanted to raise, though, is whether or not there was any discussion given to whether or not a repeat offence could instead have actually been an aggravating factor at sentencing, rather than having that presumption around imprisonment so to be so expressly stated in the legislation. Because that probably would have given a greater amount of discretion to the judiciary to make a decision as to whether or not, in their mind, it was appropriate that a term of imprisonment be used for that second offence. Now, I don't know whether or not that was something discussed by the Select Committee or considered. Obviously, the Sentencing Act has a range of aggravating factors, and it could have perhaps been that specific to offences under this law that could have been added as one. I'm also interested to know how many repeat offences have been committed already. So, and how many, if we had this legislation, how many times would you have had someone who would fall under this criteria who hasn't been given a term of imprisonment and therefore would likely to be, had this legislation existed? Always interested to know whether or not we're sorry, what was that? So I'm hearing that it's a very low recidivism rate, which is the general rule of thumb for crimes committed under these kinds of crimes. So I would be interested, because there's a low rate of recidivism, how many occurrences are we seeing where someone would have come before the court for a second time and hasn't been given a term of imprisonment? My assumption would be if it was a repeat offender, that would have been likely been the case anyway. So are we legislating for something that actually hasn't been a problem, or have there been some cases where that second offence hasn't been met with a term of imprisonment? Just interested to know the context. Next issue I'm interested in is, given that, again, we're talking about a very specific set of types of offences, we do know that relative to other types of offending, there does seem to be a relatively high success rate for treatment programs. Was any discussion had at Select Committee around agreements or MOUs or what have you between the Ministry of Justice, Mr Chair? Between the Ministry of Justice and Corrections around ensuring that if there is a repeat offence, that there is the presumption of a term of imprisonment, that there's also a presumption that there would be an appropriate corrections department-led program attached to that person's sentence. We know that there are a number of programs. They are lengthy programs. Sometimes scheduling of those programs is an issue depending on length of sentence. But it would seem ridiculous to me to have a regime where we say, look, we've got a repeat offender, they weren't in prison the first time, obviously haven't addressed the causes of their offending, not to therefore have something that also comes in and says, well, if we're giving a term of imprisonment, the expectation is that there would be treatment attached to that as well. Obviously, by and large in corrections, you do see that kind of planning, but I think if we're talking about repeat offenders, it's particularly important. Final point I want to make in part one, Mr Chair, relates to I think still clause 7. It talks about the exceptions to when an offender must be sentenced for repeat offences to a sentence of imprisonment. And the exceptions, it says, is unless the court considers that the offender should not be so sentenced, having regard to the particular circumstances of the repeat offence, so there is some discretion there obviously, and the particular circumstances of the offender, including without limitation his or her age, if he or she is under 20 years of age. So an exemption built in there around the age of the offender if we are talking about a term of imprisonment. What I'm interested in, Mr Chair, and perhaps the Minister would like to comment on, is why the age of 20 was selected here. Now, in a lot of legislation, it is true to say that we have a wide-ranging group of ages around that are considered to be the age of majority, but by and large, age of majority in a lot of legislation is 21, but not criminal justice. In our criminal justice system, as the member in the Chair Wells knows, is 17 years of age. Now, we personally don't agree with that. We think it should be 18. We breach the United Nations Convention on the Rights of the Child by it currently being 17. It's one of the lower ages compared to overseas jurisdictions. But that is the age that tends to be used to distinguish between a youth and an adult. So I am interested that the age here that's specified is 20 years of age. I'm interested in the rationale for that. It seems inconsistent. I'm not advocating that this law should say 17. I would advocate 18 perhaps, but 20, to be honest, seems odd, and it seems an outlier. Now, there might be very good reason for that. Someone who is on the Select Committee might be able to give me some justification for that, but at the moment I would say it strikes me as being a bit of an outlier and a bit of an anomaly. And there is another section of the bill where I think there's a similar age issue. But Mr Chair, I'm going to resume my seat in the hope that the Minister might be able to respond to some of the... I'm ever the optimist to answer some of these questions. Thank you, Mr Chair.
I call Penny